All right. Hello, everyone. Welcome back from lunch. All right. So I think we're going to go ahead and get started. I got a text saying like some folks were stuck in the saloon waiting on food. And so, but I think we should just go ahead and dive in, and just keep in mind, this will be recorded. So so anyone who didn't make it back from lunch yet should still be able to access it. So I am so excited to introduce our next speaker, who will be talking to us for the next hour and a half, or 2 hours. And so we have Tara Buchalter here, who is Assistant Attorney General to Office of the Attorney General, who will be giving a talk on Title 18, our criminal code, and the legal authority for investigations. So Tara is a Colorado native and attended CU for her undergraduate degree in economics and DU for law school. She served as a deputy district attorney in the 18th Judicial District for 8 years, specializing in the prosecution of special victims unit and domestic violence cases. She is now an assistant attorney general in the business and licensing section of the Attorney General's office and serves as general counsel to the Colorado Post Board. In her free time, oh, I like this. We should all have a free time sentence. She loves to ski, do yoga, cook, and spend time outdoors with her husband, kids, and dogs. So thank you so much, Tara, for being here today. We really appreciate it, and really appreciate you providing your legal expertise for all of us. And one more quick announcement. I was just told that if folks want to ask questions, we want to make sure we're recording those questions. So when you raise your hand, I'm going to come over, give you the microphone, and then you can ask Tara a question. And that's how we're going to work this moving forward. Okay, great. Thank you.
Perfect. Thank you, Becky, for that really kind introduction. Hi, everyone, and welcome back from lunch. Having the slot right after lunch is always tricky. You'll probably be a little sleepy. Hopefully this isn't too boring. I'll try to keep your attention. I've been told that the next section includes dogs, which is entertaining, much more entertaining than mine will be, but at least you have something to look forward to. So I'm going to go ahead and dive right in. We have a lot of ground to cover. My slide's going here. So our goal with this part of the conference is to basically be able to delineate a civil matter and a criminal matter, the different legal frameworks that govern both of those, how you should approach each one, and where your authority starts and stops under the law. So I included this sort of decision tree as our overarching framework. The first question you should ask when you're out investigating a complaint is whether this is going to be civil or criminal. Sometimes there's both. It's not going to be completely cut and dry in every situation, but if you know for sure it's going to be something civil, then you're looking at two different scenarios. One would be to enter the property with consent or an administrative warrant to determine a violation of Title 35, or providing food or water to a confined animal in need, in which case you don't need a warrant. Criminal, on the other hand, you're in kind of a different realm, and an important distinction that we're going to cover throughout this presentation is felony versus misdemeanor, and that's important for your purposes because you can enforce a misdemeanor animal cruelty violation through a summons and complaint, whereas if you're in felony territory, you don't have any authority and you need to contact local law enforcement. But we'll talk about that distinction, kind of best practices where you have to get local law enforcement involved, and maybe in certain situations you don't have to, but it would still be generally a good idea. So that's kind of our roadmap for today. As far as our statutes go, civil, you're going to be looking at Title 35, 42, 101 through 115. Criminal, you're going to be all in Title 18. So our criminal overview, in terms of the types of offenses you're going to see, and the mental state that goes along with those. If you're working in criminal, you know that you're going to have a criminal mens rea, which is a fancy way of saying mental state. So some of the mental states you're going to have to be familiar with in terms of their definitions are knowingly, recklessly, and criminal negligence, and we're going to get there. If it's criminal, you're also going to be looking at a possible punitive sanction for the offender, whether that is jail time, probation, or a fine. You obviously don't have the possibility of jail or probation under a civil enforcement action. And then this is a lot of information here. We're going to cover this as we go, so you don't have to commit this to memory, and this is a lot. But these are basically all of the different offenses that are enumerated under Title 18. If you are working in a civil enforcement matter, and Billy, my colleague, is going to cover this in more detail tomorrow, you're going to have a very limited scope of authority. And this will ultimately play out in a civil court proceeding. And know that you're there to establish probable cause for a violation of any specific provisions of Title 35, and you can assist with investigative and enforcement options that are available. All right, in terms of charging cases, we not only have the state charges under Title 18, but oftentimes there are local codes, ordinances, regulations, whether that's municipal or at the county level. So know the jurisdiction that you're working in. You're going to have lots of layers in terms of not only civil and criminal on the state level, but also make sure that you're aware of particular jurisdictional nuances in terms of what those local ordinances say. Serious offenses should always go to a state court and should be charged under a state law. We're going to get into what a serious charge is and how you know when you should be looking at state level offenses. So just in terms of definitions, misdemeanor versus felony, the scale goes from an M3 to an M1 in misdemeanor land, M3 being the lowest and M1 being the highest. Petty offenses are below even a Class 3 misdemeanor. In terms of penalties, for an M3, the absolute most that someone could get in terms of incarceration is 0 to 6 months. An M2 is between 3 and 12 months, and an M1 is between 6 and 18 months unless it's an extraordinary risk crime, in which case it's 2 years. All kinds of nuances there that you don't have to commit to memory, but just so you have an idea of the ballpark penalties that are available. Felonies, for your purposes, you really don't have to know much about anything above a Class 4 felony. Felonies go from level 1 through 6, 1 being the highest and 6 being the lowest. You hopefully will not encounter any F1s, 2s, or 3s. If you do, something has probably gone very wrong. But the highest level that you'll encounter is a Class 4 felony, which is animal fighting. And the possible penalties for that are 2 to 6 years in the Department of Corrections, not just county jail. Possible fine, mandatory parole of 3 years after the release from DOC. But all of these offenses that you'll be working with are also probation eligible. None of them carry any mandatory prison time. Misdemeanors will always be written into the county court of the appropriate jurisdiction, and felonies will go to the district court. What that means in terms of the ultimate disposition, if it goes to trial, a misdemeanor will be tried to a jury of 6, and a felony will be tried to a jury of 12. So in 18.9.201, there's a whole slew of terms and definitions. Some are defined, some are not. But as always, the law tries to create black and white in a world of gray. So as much as there is, definitions on paper of all of these things, these are always going to be a very fact-specific analysis when you encounter them in the field. So it may not look the way you expect it to when you get there. And in our office, we're constantly asking ourselves, well, does this meet the definition? Is this interpreted in case law anywhere? Has anyone else encountered this? These are not clear-cut definitions by any means, but the statute at least tries to give you a starting place. Where there is not a set definition in the statute, I would encourage you to use the dictionary and try to get the plain meaning of the statute as much as you can. All right, so now we'll dive into the actual substance of each of these criminal charges. And we'll start with kind of the biggest one that I think you're likely to encounter, which is animal cruelty. And there's going to be misdemeanor animal cruelty, and then felony animal cruelty or aggravated animal cruelty. And we'll talk about the penalties of each, but know that those are going to be the two big categories within this. So animal cruelty constitutes knowingly, recklessly, or with criminal negligence, and I've highlighted in red that element of what we call mens rea, or the mental state, overdrives, overloads, overworks, torments, deprives of necessary sustenance, or unnecessarily or cruelly beats. Now, in terms of this mens rea or mental state, if you are investigating something like this, you should be asking yourself, how do I establish this? How do I establish that someone did this knowingly, that this wasn't totally inadvertent, or that they're acting recklessly or with criminal negligence? And this is where talking to witnesses, taking photographs of, just how horrendous something looks, that this would be incredibly obvious to just about anyone looking at this animal. Talking to the owner or the suspect, and we'll talk about how to go about doing that and all of the legal parameters that would govern that. But this is where talking to people and really your evidence gathering is going to help you establish that. Section 1A also includes allowing an animal to be housed in a manner that results in chronic or repeated serious physical harm, carries or confines in or upon any vehicle in a cruel or reckless manner. This is where you would see situations such as an animal being left in a car that gets overheated, the overcrowding of a semi-truck, or animals left unsecured in the back of a truck in a way that could potentially cause them harm. That's basically what this is geared towards. Also under Section 1A, engages in a sexual act with an animal. Not very common, obviously, but we did see them from time to time in the DA's office. They would come to the Special Victims Unit, and they're pretty terrible cases, obviously. Having the charge or custody of any animal and failing to provide proper food, drink, or protection from the weather consistent with the species, breed, and type of animal. And this could vary, right, from type to type of dog. Like certain like flat-nosed breeds of dogs might have less tolerance for heat than other types of dogs, that sort of thing. So you might want to just be cognizant of the certain breeds that you're working with on the ground. And abandoning an animal. So any person that intentionally abandons a dog or a cat automatically ends up in this misdemeanor of animal cruelty. Now, establishing abandonment can be hard when you're actually out in the field investigating. You would have to observe the situation for a period of time to ensure that the owner isn't returning. You might talk with neighbors on the ground. if there's any surveillance available that you can check to see if someone is coming or going. But this could be hard to prove in a criminal court if you only observe for a small slice of time. Even if there's an empty apartment, there could be someone still coming back. So just be aware that you probably have to go back multiple times and establish sort of a continuous surveillance of that area in order to establish that the person is not returning, that they have not made any arrangements for something like a dog walker or a caretaker to come back. That could potentially get you in trouble if that hole in the investigation isn't filled. So the penalty for an M1, which I said earlier, is going to be between 6 and 18 months in the county jail. Certain misdemeanors can go up to 2 years in the county jail, but none of them that you guys should be concerned about. Where you get into felony territory is either with aggravated animal cruelty or if it is a repeat offense. I can tell you, at least from my experience with this, it's unusual to see a repeat offender in terms of a conviction. It's not that easy to get a conviction, especially to these types of offenses. I usually found that defendants were very resistant to taking any sort of animal cruelty plea. These often ended up going to trial for that reason, because there is that stigma associated with a conviction to an animal offense. So seeing someone who had a conviction was a big red flag, because that told us that not only do they have a prior conviction, but they probably engaged in that conduct multiple times before there was really sufficient evidence for them to take a plea and be convicted of that. So if someone has that conviction, that sort of told us, like, this is a pretty bad actor. We don't see that very often, but when you do, and then they get a second or subsequent offense after that, it's elevated to an F6. A second felony conviction, so one or more convictions of aggravated animal cruelty, would get you up to an F5. I never saw that in my time, but that's where it's laid out in the statute. So the difference between plain old animal cruelty and aggravated animal cruelty is going to be your mental state. A person who knowingly tortures, needlessly mutilates, or needlessly kills an animal has committed aggravated animal cruelty, whereas if someone acts knowingly or with criminal negligence, they're in misdemeanor territory. This is a subtle distinction and could be difficult to prove. This is one reason why it could be really helpful from the outset of an investigation to get local law enforcement involved, because it's going to be really hard to know at the outset of an investigation on the ground whether this is going to be a misdemeanor and you have enforcement authority, or if it's going to be a felony and you don't. So it's better to get local law enforcement involved at the outset, because it's certainly possible that what could start as a misdemeanor investigation, you're sure it's a misdemeanor, but as you talk to more witnesses and gather more evidence, it becomes apparent that it is a felony, and now you are beyond your authority. So better to get law enforcement involved at the outset and act as their partner, being a witness. You can be an affiant in their search warrant. You can be the expert witness. They really rely on your expertise, but getting them involved at the beginning will prevent you from getting into some unnecessary hot water. So with the aggravated cruelty to animals offense, that's going to be the F6, which does include mandatory jail or in-home detention of 90 days, and then the second or subsequent conviction would be elevated to an F5, and that carries 1 to 3 years in prison or can be probation eligible as well. A key part of this sentencing structure is that a comprehensive evaluation is required. And I have seen these evaluations done, the pre-sentence investigation reports, and they are really comprehensive, and they really help the judges decide what sort of is at the root of this criminal behavior and what is going to prevent this person from committing it again. Whether that's substance abuse, mental health, what their educational history is, they go really in depth. So that's a good thing that these are required, and that's one good reason to have someone plead to this offense is that it does trigger that evaluation requirement, which is really helpful for judges in sentencing. So a couple hypotheticals that we're going to get into, and I'm going to ask you guys whether you think there's probable cause to investigate a criminal animal cruelty offense, and also if there's sufficient evidence to investigate a civil animal mistreatment. And keep in mind that sometimes these are going to overlap and they're not going to be totally clear-cut. So situation is you are driving down the road, there is an open pasture that's not protected, but you see what is clearly a companion horse from the side of the road. It's plainly visible that there's redness and an odd shape on its muzzle. Upon getting closer to the horse, without even going onto the property, you see that its halter is embedded in its skull. So any brave volunteers want to venture a guess as to whether there might be probable cause to investigate criminally? Okay, I like that. Heck yeah, I'm with you there. And what about civil? Can you investigate civilly? I'm seeing some nods. Yeah. It's yes to both. And so this is where that Venn diagram sort of criminal and civil are going to overlap. In this situation, I would recommend proceeding civilly, but also getting local law enforcement involved. And so here's that distinction again that we talked about. The difference between a felony and a misdemeanor is going to be the mental state. And so in this case, how do we know if the owner has acted recklessly, which would land him in a misdemeanor, or knowingly, which would land him a felony? And that's a subtle distinction that ultimately the prosecuting attorney is going to have to make in terms of how much evidence they think they have to go forward on one or the other. And you would, again, probably want to talk to the owner. I think that would be your best bet. If he has been warned before, if he has a criminal history of this nature, if he has a history of the department being involved with his activities before, and there's documentation that he's been warned, I think that could get you to the level of a felony. If he has no history, let's say he just moved from New York City, he's never owned a horse before, someone told him this was common practice, he had no idea, I mean, maybe that lands you a misdemeanor. It's reckless, you can see the redness on the horse's face, so it's pretty obvious that the horse is in some pain, but maybe we don't get to the level of knowingly. So that's where your evidence gathering comes in. The photographs, how much redness? Would this be really obvious to just about anyone? Talking to the owner, other witnesses, that's how you are going to get your distinction between misdemeanor and felony. And ultimately, it won't be your decision. Even if the local law enforcement writes it up as a felony and hands their affidavit for arrest warrant to the DA might take a look and say, I don't think this rises to the level of a felony. I don't think we can prove that beyond a reasonable doubt to a jury of 12. We'll have a better chance of proving the misdemeanor. So ultimately, that'll be the prosecuting attorney's decision. So another hypothetical here, has the defendant committed animal cruelty? And if so, are we in felony or misdemeanor territory? So defendant is kind of pulling a Mitt Romney here, and he's driving under 25 miles an hour with the family dog riding in the flatbed of his pickup truck, along with various camping gear and tools that are loose and rolling around. Any thoughts? How so? Okay. Yeah, absolutely. Would you think this is felony or misdemeanor territory? Yeah. Yeah. And this also depends. This is one of those really fact-specific scenarios. This could change based on how long the dog is back there. Are we talking 5 minutes from, maybe the barn to the house? We're probably not in criminal territory. 5 hours driving down the highway? Yeah, I think we could be in criminal territory. Is the dog in a kennel, and is that kennel secured to the flatbed of the truck? That could make a difference. What are the weather conditions? Is it extremely hot or cold? Are we driving through a blizzard, driving rain? That could all really make a difference here. And when the prosecuting attorney takes a look at this report, if they see that, this was for 5 minutes in, lovely 65-degree spring weather, the dog was in a kennel, it was secured, we're probably not going to be charging a crime. So I would say when you get reports like this, details really matter. Make sure you document the type of truck, the type of dog, the type of terrain they're driving over, how long they were driving, what type of tools. Are they blunt tools? Are they metal tools? What was the weather that day? All of these details can really matter in shaping a criminal investigation down the road. So here is where we're going to make kind of a finer distinction between the felony or the misdemeanor. So the hypothetical, which is really this is a terrible scenario to envision, but let's say this defendant has needlessly killed his companion dog because he's moving to a new apartment building that doesn't allow pets. He doesn't have a criminal history, so no prior convictions. Are we looking at felony or misdemeanor? Yeah. We're looking at a felony here because he knowingly killed the dog. I think it would be a huge stretch to say that this was anything but reckless, unless there was some sort of an accidental death. But if he did it on purpose, we're in knowing territory, and he's committed a felony. So overworking a dog, I don't know how often you would necessarily see this, but if the hypothetical were that the defendant is training for a marathon and he has his companion dog running with him, he's running 20 miles a day in preparation for his big race, and it's clear that this dog has an injured paw, keeps trying to stop and lick the paw, and is whimpering a bit and doesn't want to continue, but the owner keeps getting it up to continue the run. Has the defendant overworked their dog? Yeah, I would say so. The one exception that could possibly apply here is if this were pursuant to some sort of rehab recommendation from a veterinarian. I have a hard time imagining a veterinarian recommending 20 miles a day for a dog. But let's say it was part of a rehab recommendation. That could potentially be one exception that would get the defendant off the hook here.
Does the paw injury where the dog sustains the paw injury matter in that scenario at all? So say it was not an injury that was sustained during the run, you can't prove that the injury was caused as part of overworking the dog. Does that matter?
That's a really good question. I don't think in this scenario you would necessarily be able to prove that the injury occurred as a result of the running, but it wouldn't matter. Let's say the dog injured itself on some metal fence edging in the yard, which my dog has done before, which that is no fun, and has the injury from that, and then the owner continues to make it run 20 miles a day despite this injury. That would still be overworking. Great question. Thank you. So animal fighting, This was a less common offense, at least in the jurisdiction that I was in. But the definition is that no person shall knowingly cause, sponsor, arrange, hold, or encourage a fight between animals for the purpose of monetary gain or entertainment. And we'll kind of get into some of the pitfalls of charging a crime like this. This is going to be a felony, so if you encounter animal fighting anywhere in the field, get local law enforcement involved first thing. But just so you kind of know what you're looking for and know what the statute prescribes, one of the elements would be encouraging an animal fight. So that could mean a lot of things, right? Especially in this day and age of social media. Let's say there's a Facebook page for this upcoming dog fight, and someone posts on it like, you know, go get them, this is gonna be awesome. Are they guilty? Maybe. That's a lot harder to prove than someone who is actually on scene, in the front row, egging them on. So you might encounter some gray area there. When the statute was written, and they used the word encourage, you know, the people who wrote this statute may not have envisioned someone on Facebook making a post or someone on Instagram making a post, but in our day and age, it could apply. So it's very broad, and be aware of that. In terms of owning animals that are trained to fight, you would have to prove intent to fight. So the statute says owning, training, transporting, breeding, selling, transferring, equipping a fighting animal, which covers a lot, but mere possession isn't enough. You would have to prove an intent to fight. That intent element is going to be the trickiest part. That's where you would need to probably interview them, talk to witnesses, check out their history. Yeah, that would be the tricky part, I think, for a prosecuting attorney is proving that element to a jury. So encouragement could mean allowing the fight to occur on your property. It would have to be knowingly. Allowing a fighting animal to be kept, boarded, housed, trained on, or transported to any property owned or controlled by you, and using any means of communication for the purpose of promoting a fight. But all of this has to be knowingly. So if a defendant had no idea that, you know, his tenants on the back 40 of his land were doing dog fighting and he's not actually on the premises very often, you might have a hard time proving knowingly. If he's invited to the dog fights and enthusiastically attends, then yes, I think you have knowingly. So a first offense is going to be an F5, and then a second or subsequent offense is an F4. These are all going to be probation eligible crimes. Dangerous dog statutes. So there's the state statute, and then you're probably going to have a myriad of local, county, and municipal ordinances as well. So be aware of all of those layers and how they interact. But a dangerous dog at the state level means any dog that inflicts bodily or serious bodily injury upon or causes the death of a person or domestic animal. It could demonstrate tendencies that would cause a reasonable person to believe the dog may inflict such injury, or if it's engaged in or trained for animal fighting as described in the last section. Restitution is mandatory if someone is convicted of this offense. So where this will differ in terms of misdemeanors and felonies, it's going to depend on the type of injury and also the person's criminal history. Is this a first or second offense? Again, great place to get local law enforcement involved and sort of be their witness, their expert, their partner, because it might not be apparent at the outset whether this is going to be a misdemeanor or felony offense. Sometimes what looks like plain old bodily injury at the beginning could become more serious if their injuries progress somehow and turn into serious bodily injury, or maybe you're not aware of their criminal history. They might have another such conviction from out of state that local law enforcement discover. So all of this could move it from misdemeanor territory to felony territory. So good idea at the outset to get local law enforcement involved. So in terms of the actual penalties, let me go back a slide. So a first offense that just has bodily injury is going to be an M3. That's the lowest misdemeanor there is. A second or subsequent offense with bodily injury is an M2, so that goes one rung up on the ladder. And the dog is euthanized. It's mandatorily euthanized for a second or subsequent offense. So bodily injury in this context actually, it doesn't use the usual definition that Title 18 has for like every other type of offense that involves bodily injury. It's specific to this dangerous dog statute, which is any physical injury that results in severe bruising, muscle tears, or skin laceration requiring professional medical treatment, or any physical injury that requires corrective or cosmetic surgery. Serious bodily injury is the actual Title 18 definition that's used for all other offenses involving SBI. Why they have a specific one in this context for bodily injury, I'm not totally sure, but that's what it is. Serious bodily injury is something that has to be signed off on by a physician. A prosecuting attorney is probably not going to accept a case for charging unless the serious bodily injury is confirmed by the treating physician or surgeon or whoever it is. But that's a very specific definition. All law enforcement agencies are going to have the SBI form. They know to hand it to the attending physician when they're investigating a case involving SBI, but it's got to be in there. So SBI is either at the time of the actual injury or later, and that's an important point too, involves a substantial risk of death, a substantial risk of serious permanent disfigurement, a substantial risk of protracted loss or impairment of the function of any part or organ of the body, or breaks, fractures, or burns of the second or third degree. What is tricky about these definitions is that I could see some gray area in terms of a severe risk of permanent disfigurement and skin lacerations or physical injury that require corrective or cosmetic surgery. So that, to me, says that there's actually could be quite a bit of overlap, and it might just depend on the severity. It's going to be a judgment call that the prosecuting attorney makes. We would often get, in a lot of contexts, not just dangerous dog cases, but we would get cases that were charged as serious bodily injury because it was a broken finger. Yes, that meets the statute, there's a broken bone, but because it was, a very minor fracture and just wouldn't have a long-term effect on someone's ability to use their hand or that finger. I mean, sometimes it might, but that would be one of those judgment calls where we would say, let's charge this as a misdemeanor. Or on the other hand, maybe something comes in as a misdemeanor that was charged under the provision of a physical injury requiring corrective surgery. Maybe by the time the prosecuting attorney gets it, or by the time it's moving through the criminal justice system, the scars are still not going away, and the person looks like they're not really healing as well as expected, and they're going to be permanently disfigured. Maybe then they upgrade that to a felony. So these are not clear-cut distinctions by any means. Again, something the prosecuting attorney will decide, but definitely get local law enforcement involved. So serious bodily injury, a first offense is going to be an M1. A second or subsequent offense is going to be an F6, and the dog is euthanized even on a first conviction. So those are the big distinctions there. So it could also depend on what type of injury is caused in terms of whether it's injury to property, the death of another domestic animal, or the death of a person. In the case of a person dying, we would be talking an F5, and the dog is euthanized even on a first conviction. Death of another domestic animal, a first offense would be an M3, and a second would be an M2, and the dog is also euthanized even on a first offense. Injury to property, we're only in petty offense territory. Yeah.
Did you just say that for death of a domestic animal, if it's the first offense, it's euthanasia for that dog, or second? I'm sorry. Do you want me to? Sure. Do you want me to re-ask? Oh God. Hello. Okay. Okay. So my question was for death of a domestic animal. That dog is euthanized. Is that even in cases where it's the first offense, or is that only for second?
It is, even on a first offense.
Okay.
So you can imagine how these kind of cases would get really contentious in the criminal justice system, because people are very attached to their dogs, understandably. So these were contentiously fought cases that often went to trial. Some exceptions to the dangerous dog statute, if the dog is working with some sort of professional, whether that is a peace officer deployed as a canine officer, or it is a veterinary healthcare worker, a dog groomer, humane agency personnel, professional dog handler or trainer, and the dog causes some physical injury to those people while they're acting in the performance of their professional duties. The dangerous dog statute would not kick in unless, here's the exception to the exception, we love those, the owner failed to comply with notice requirements from a previous dangerous dog conviction. So if someone is convicted of owning a dangerous dog, they are then required to notify their vet, their dog walker, any sort of veterinary healthcare workers, trainers, anyone like that, of the conviction. And if they fail to do that, then they could be on the hook for another charge. The other exception is that the injury or death to a domestic animal was naturally associated with the work of such a dog. So hunting dogs could potentially fall under that depending on the circumstances, but be aware of that as well. Yeah.
So my question was, is domestic animal defined? And if so, what falls under that? Because, obviously hunting is hunting wild animals, but is livestock encompassed in that as well?
That is a very good question. I don't know off the top of my head what the definition is, but it is defined in the statute, and it has a separate definition from livestock. I actually want to make sure that I look that up before I leave today and circle back to it, because I don't have it right at the tip of my fingers, but there is a definition in the statute. So restitution kicks in after someone has either pled guilty or they've been convicted at trial. You cannot get restitution unless someone is actually convicted. And they don't have to be necessarily convicted of the top charge or even of the animal cruelty or dangerous dog offense. Let's say they take a plea to a lesser offense, harassment, disorderly conduct, whatever, it's pled out. They could still be on the hook for restitution even if they don't plead to that animal charge, but it only kicks in once the person has been convicted. So the victim is not going to get any restitution until essentially the case has closed. They don't get restitution up front or while the case is pending. And this can be really frustrating for victims who have to wait, and the defendant might even be dragging it out. But unfortunately, the ball is sort of in the defendant's court at that point about whether he's going to take a plea or take it to trial. And that can be frustrating for victims, but they don't get restitution until the case is closed and a conviction has actually entered. But the goal of it is to make the victim whole and provides for the reimbursement of any out-of-pocket expenses. For example, if they had to get some sort of cosmetic surgery from a dangerous dog attack, then that expense would be covered by restitution. Impoundment is our next big topic. How are you guys doing? Do you want a stretch break, bathroom break? Okay, excellent. We'll take 5. Does that work, Becky?